Hello and good evening, everyone, and welcome to this evening's webinar on selection and duties of a special needs trustee. At this time, I'd like to introduce Debra Schuster, who is a practiced elder and disability law attorney. Debra's practice focuses on elder law issues, a growing area of law with few experienced practitioners. Her personal experience with her mother and grandfather, both of whom had dementia, has given her insight into the issues families face when caring for a loved one, which led her to become a certified elder and adult mediator. Some of her areas of practice include Medicare claims and appeals, Medicaid planning, filing Medicaid applications, estate planning, mental health law, guardianship and conservatorship representation, financial exploitation, special needs planning, and much, much more. So without further ado, I introduce you to Debra Schuster.
So tonight, I'm going to be talking about selection and duties of a special needs trustee. As Anne so wonderfully introduced me, as you can hear, I have a very broad-based practice, but the focus of all of what I do is on vulnerable populations, and certainly individuals with special needs are a part of that population that I work with all the time. Children, adults, and obviously elders. What we're going to talk about tonight are some definitions, because this is, as with many legal subjects, it's full of legalese and jargon and abbreviations. We're going to obviously talk about what is a supplemental or special needs trust? What are the types? Who can create them? And what are the uses of these trusts? What are the trustee duties and the types of trustees that can be appointed? We're going to be talking about benefit programs. We're going to be talking about Medicare, Medicaid, which in Missouri is known as MoHealthNet. We're going to be talking a little bit about SSI and SSDI, resources, and obviously questions. So many of you may be familiar with some of this information. I know that from the years that I've been doing these presentations, I see certain people come to these repeatedly, and I understand why. When you have someone who has special needs, you can never have enough information. You can never be knowledgeable enough, because the field is always changing. And to that end, I do want to add a disclaimer. When I first wrote my bio, there were not that many elder law practitioners. I started practicing elder law and disability law in earnest in 1999. And since then, there are many, many excellent elder and disability law practitioners. So, you know, when you are looking for an attorney, it very much is not only what their skill set is, which is extremely important, but also what your gut feeling is, what relationship you feel that you can have with that individual, because this is not just an area of law. This really focuses on the full spectrum of an individual's needs and really their family. So we look at many issues beyond just creation of documents and what the law provides. We look at what their social situation is, obviously their benefit situation, what their support systems are, what their needs are, what their abilities are, as well as obviously what their challenges and disabilities are. So it's really important that you find an attorney and kind of a team that can really respond to what your family's needs are, and certainly the needs of the individual who you're caring for that has special needs. So when we talk about supplemental or special needs trusts, there's a reason it is called a supplemental needs trust. This is a very special type of trust, and actually it's a federal law, which I really am so enamored with, because it provides such phenomenal support for an individual who has special needs. It was designed by law to shelter, to protect assets that may come to an individual in a variety of ways, the way we'll talk about, who has disabilities, such that those funds are preserved on their behalf to be used specifically to enhance their quality of life and to supplement and not replace public benefit programs which that individual may be entitled to, so that they can both become eligible for public benefit programs that are means tested, meaning that the programs look at assets and or income of that individual before they can become eligible for those benefit programs that we will talk about later, and also to preserve as a nest egg the monies that come into the special needs trust. And I'll explain how that can be done, because there are a variety of ways. So first, let's start with some definitions. Grantor is the term used to define the person who creates a special needs trust, and usually whose assets fund the trust. And as with the law and many other professions, there are a number of terms that can define an individual who is in this category. It is usually grantor, but it can also be called a settlor, because you're settling a trust or establishing the trust, or trustor or trust maker, which are actually more straightforward terms for that individual. But very often, the grantor is actually the disabled individual. So for example, if a child comes into an inheritance directly in their name and has special needs such that they need public benefit programs, but they certainly don't want to lose an inheritance, a parent can establish the trust, but the grantor is actually the child, because it is that individual's funds, the special needs person whose funds are being used to fund the trust. So it can sometimes be a little bit confusing. And the trust itself will define by its terms who is the grantor and who is the trustee. So the trustee is the person or entity that manages the trust assets and uses them on behalf of the disabled individual. And as I said, it can be a person or an entity, and we will talk at great lengths about that. But the document itself, for those of you who don't have a trust or have not seen one, it really opens with a paragraph that says, this special needs trust is created by grantor, that person's name, and the trustee is also named as the person who's going to be administering the trust or using the funds that are in the trust on behalf of the beneficiary. And of course, the beneficiary is the disabled individual, also known as the special needs person. So when we talk about disability, we're really talking about the definition or the clinical criteria used by the Social Security Administration. And of course, more alphabet soup, SSA is its abbreviation. And the inability of that individual to engage in what is known as substantial gainful activity, or SGA, due to that person's disability. And under the Social Security Administration, that has been defined to be a specific amount of ability to earn money through work. So disability in the eyes of the Social Security Administration first starts with looking at someone's disability through the clinical criteria that's presented to them, and whether their disability renders them unable to earn $2,110 for an individual who is blind, or for an individual who is not blind but is otherwise disabled, $1,260. And these are the dollars that the Social Security Administration has used as this definition for substantial gainful activity in 2020. This amount changes almost every year. So we'll talk about what happens if someone works and makes less than this, or if someone makes more than this. Then, of course, there's the definition of incapacity. And those of you that may have individuals who have special needs that need a guardian, the term incapacity is used very often in that context. And in the environment of special needs, incapacity really refers to a trustee's inability to manage the financial affairs of the trust so that a named successor trustee can take over those duties. Because it's presumed already that the beneficiary is either disabled and or incapacitated, one or the other or both. But when we have the definition of incapacity in a special needs trust, it's really referring to the trustee's ability to continue to administer the trust. As we just said, a person may be disabled but not incapacitated. And federal law recognized this. It just took almost 20 years since the inception of the law that established, or the legislation that established special needs trusts. Because in 2016, President Obama signed into law the ability of someone who is disabled but not incapacitated, who does have the mental ability, the capacity to understand and handle their finances, to create their own special needs trust. So when we talk about special needs trusts, as I said, we talk about supplemental needs trusts, we talk about special needs trusts. They refer to the same document, and the abbreviation is SNT. So you'll see that throughout the presentation. There are three primary types of special needs trusts. There is the third-party special needs trust, and that is specifically created to avoid assets going directly to a disabled beneficiary. And that's usually through inheritance, through parents, grandparents, other family members, or gifts being given to that individual, monetary gifts, or, as we shall see, potentially a house or a car, if that is feasible, or vehicles being given to a disabled individual. And so when we'll talk about this more later, but the third-party special needs trust is created by another individual specifically to enable monies or items to go for the benefit of someone who has a disability, but so that those things do not go directly into that person's name. A self-settled special needs trust, or a first-party special needs trust, is created with the assets of a disabled person. So this would be a case where someone did receive an inheritance directly through, for example, the will of a deceased relative that leaves money directly to Debra Schuster. If I was a disabled individual and I needed public benefits and I received an inheritance that named me specifically in a will or a trust, then certainly I would want a special needs trust to be created for my benefit so I wouldn't lose either my eligibility for public benefits or the inheritance that was left for me. But it can also be created with a court judgment, a settlement, public benefit back awards, and certain types of income earned by a disabled individual. Then the other type of special needs trust, which is not quite as common, is called the sole benefit special needs trust. And this is a very narrow category of special needs trust that is created by a person, usually an elder individual, who themselves is seeking to become eligible for Medicaid, usually to be able to move into a skilled nursing facility, because Medicaid allows someone who has a disabled child or a disabled grandchild to leave that disabled child or grandchild money and still themselves qualify for Medicaid. So Let me unpack that a little bit. If there's an elder or an individual who is seeking themselves to become eligible for Medicaid, usually nursing home benefits, because Medicaid pays for benefits in skilled nursing facilities, that individual is allowed to specifically create a special needs trust by leaving monies to a disabled child, adult child, or a disabled grandchild, so that the elder or the individual seeking those nursing home benefits through Medicaid can qualify immediately by transferring that money to a disabled child or disabled grandchild. And in that way, the disabled child or grandchild can themselves also become eligible for Medicaid if that in fact is needed. So let's talk about that first party or self-settled special needs trust. This is authorized under federal law called OBRA 1993, and it's found at 42 USC 1396 P D4A. So these are commonly known as D4A trusts. These trusts are established by a parent, a grandparent, a legal guardian, a disabled individual that has mental capacity, and as I said, as of 2016, it took that long for Congress to catch up with the law, or a court with the assets of a disabled individual, so long as that trust is created and funded when the disabled individual is 65 years of age or younger. If an individual is over the age of 65, you cannot create a special needs trust with that person's funds. So another aspect of this first party or self-settled, meaning it's the money of the disabled individual, when the court creates that special needs trust, it is not the court creating the special needs trust. It is entering an order allowing the establishment of a special needs trust. And again, this may seem like legalese, which it is, but when we petition the court to ask that a special needs trust be created, the court has to use specific language. So it does not write the trust. There are either attorneys who can write up the trust, that can draft the trust based on meeting with the grantor or the person that's creating the trust, or there are entities that specifically have their own documents, nonprofit entities that serve as trustees for special needs individuals who have their own documents that are form documents that are special needs trusts. Also, you'll note that the law does not allow a person appointed under a durable power of attorney, known as an attorney in fact, to create a special needs trust. And there have been lawsuits about this. So if a parent is creating a special needs trust for a child, even if that parent is the attorney in fact for that child, and the child has created durable powers of attorney, when the parent creates that trust cannot state that this trust is created by Debra Schuster, attorney in fact for. It has to say Debra Schuster, mother of or father of the disabled individual. There have been many lawsuits about that have invalidated special needs trust because of that inaccurate use of language. So some features of self-settled special needs trusts. The individual, the beneficiary of the special needs trust, must be disabled in accordance with the then current Social Security definition of disability. So very often, an individual who is the beneficiary of a special needs trust will be receiving supplemental security income, or SSI, or may be receiving Social Security disability income, either because of their own work record or because of the work history of a parent. And we'll talk more about that later. But even if they've not been determined to be disabled by Social Security, meaning that they applied for Social Security and there's been a formal award or determination in writing that that person's disabled, if that person meets the criteria set forth by the Social Security Administration, they can be the beneficiary of a special needs trust. And this is particularly pertinent when we talk about third-party special needs trusts. So, a special needs trust that is self-settled with the funds of a disabled individual must be for that sole benefit of that disabled individual. So if the trust, for example, owns assets that are used by a family, and in this context, we're usually talking about a residence, family members must pay their pro rata share of utilities, of mortgage payments, of anything pertaining to the house, because the benefit of a self-settled special needs trust is really to be for the sole benefit of the special needs trust beneficiary. And if an entire family is living with that disabled individual, which unquestionably is to the benefit of the disabled individual, those other family members must still pay their pro rata share of expenses related to the house. A self-settled special needs trust must be irrevocable. If it is not irrevocable, meaning that it cannot be changed, then it will not be accepted by public benefit programs. They want to make sure that the terms of those trusts are unchangeable, particularly specific language that we'll talk about in a minute about payback for any Medicaid benefits that the disabled individual may be receiving. Now, that being said, and the law being the law, even if a trust is irrevocable, when I draft special needs trusts, I always create language whereby the trustee can change administrative provisions to make sure that if the tax law changes, if the needs of the special needs individual changes, if there are changes in the law, that certain administrative provisions can be changed to reflect the needs of the individual or changes of the law. So it's not completely irrevocable, but certain terms are irrevocable, and we'll talk about that in a minute. A beneficiary of a self-settled special needs trust cannot dictate how funds are dispersed or expended. That is one of the key features of special needs trusts in general, because if the beneficiary can compel the trustee to use those funds in a certain way or dictate how funds are dispersed or used, public benefit programs are going to consider those funds accessible to that individual. So that's why there's this arm's length relationship between the beneficiary and the trustee. The funds are used for the benefit of the beneficiary, but the beneficiary cannot require, demand, or compel how those funds are used or distributed. The trustee needs to calibrate distributions to the beneficiary on the basis of what public benefit programs the disabled individual is participating in, because the rules vary depending upon the public benefit programs, as many of you are aware, that the individual is participating in. The most significant provision in a self-settled or first-party special needs trust is it requires payback of Medicaid. Under both federal and state law, a self-settled first-party D4A trust, those are all the same type of trust, must have payback language that states upon the death of the beneficiary, a Medicaid program that is paid benefits to that individual must be paid back for the benefits paid during that individual's lifetime. So the specific language is an amount equal to the benefits paid during the Medicaid recipient's lifetime from any trust assets remaining. Now, only if receiving Medicaid after age 55 or if in a skilled nursing facility, if we're talking about skilled care. The Special Needs Trust Fairness Act was the law that I was referring to that President Obama signed in 2016 under the 21st Century Cures Act. that added literally the phrase a disabled individual to the list of individuals who can create a first-party special needs trust. Again, parent, grandparent, legal guardian, disabled individual, or a court. So the disabled individual must have the requisite mental capacity to understand and create that trust. Because whenever I meet with an individual and I'm creating documents for them, I'm asking them very detailed questions about the terms of the trust. Now, certainly, because we're dealing with a very unique type of trust, the law that enables the creation of special needs trusts has a lot of language that must be included in the trust, regardless of someone's desires. But there are terms that people can choose who they want the trustee to be. A beneficiary cannot be the trustee of their own special needs trust, even if they are creating their own trust. Because again, public benefit programs would see that as the assets being available to that person. And that is specifically why this law was created, because it enables this trust to basically shelter those funds and be used for the person's benefit. And if they're their own trustee, they're one and the same. So let's talk about third-party special needs trusts. These are created through the estate plan of a parent or a grandparent or anyone who wants to provide an inheritance or gift for a special needs person. A third-party special needs trust names the trustee of the disabled person's special needs trust to receive the inheritance or the gift that is created through a testamentary trust, a revocable living trust, or a standalone special needs trust. Now, I've just thrown 3 different trust names at you in addition to special needs trust. So if someone is leaving Anne an inheritance or $10,000 and Anne is a special needs person, the way a third-party special needs trust should work is that it would say Debra Schuster, trustee of the Anne Mangelsdorf Special Needs Trust. So that identifies the trustee, me, and Anne, the special needs beneficiary. And the way this is done is when I'm meeting with clients who tell me they have a special needs child, and we're talking about the creation of a special needs trust, very often we're talking about parents who want to leave money to their child through their own estate planning. And so they're creating their own revocable living trust that their own money is going to be used to fund bank accounts, life insurance, money market accounts, etc. during that parent's lifetime. But upon their death, there's a provision in their trust that provides for a special needs trust for their disabled child. And so upon their death, that special needs trust is created, and not until then. Now, a last will and testament can also have a special needs trust provision, and that is actually a will, a last will and testament, that identifies how someone's assets are going to be distributed, but it has a specific clause in it or article that states, for my son Jim, his inheritance will be handled through this special needs trust that is reflected in that last will and testament. Or obviously someone can have a special needs trust created and drafted that stands alone on itself that can be funded immediately. And so the question is, as a parent or someone who wants to create a special needs trust, what type of special needs trust is going to be most beneficial for the disabled individual at that point in time? Many parents are already paying for everything on behalf of their child, so there really isn't a current need for a special needs trust now. Their desire is to have that special needs trust be created when they die, when the last of the parents die. And that's when any money, any inheritance is going to go into that special needs trust and be used for that disabled individual. Some people, however, want to create a special needs trust now because they have access assets and they want to create a trust now that can just be used to pay for their, for example, adult disabled child's needs as they may arise. So it really depends upon what the needs of the individual are and what the financial wherewithal of the person creating the trust and funding the trust is. So again, all inheritance should pass to a disabled person through a special needs trust. Under a third-party special needs trust, the beauty of these trusts is that there is no Medicaid payback requirement because they're created with the assets of another individual. So a disabled person can receive assets from almost any source as long as it doesn't come directly to them, and in their special needs trust, that third-party special needs trust, there's no requirement that Medicaid be repaid. Now, if a disabled individual is receiving SSI, supplemental security income, funds should not be used even through a third-party special needs trust for housing or food, because that could jeopardize their eligibility for SSI, and we'll talk about that in a little bit. So the third type of special needs trust is that sole benefit special needs trust. And again, this is probably the least used special needs trust because it's created by an individual who's specifically seeking to become immediately eligible for Medicaid, and it's usually for nursing home benefits. And again, it's because the law allows transfer of assets from an individual seeking to become eligible for nursing home Medicaid to a disabled child or grandchild. So it enables, again, the person who is transferring the assets into this sole benefit special needs trust to become immediately eligible for Medicaid, and it enables the recipient or the beneficiary of this sole benefit special needs trust to become eligible for Medicaid or to maintain eligibility. The sole benefit special needs trust, like the first party or self-settled special needs trust, must have a Medicaid payback provision. Even if the disabled person does not end up receiving Medicaid, Medicaid payback is required because the person who funded the trust did so in order to receive Medicaid themselves. So even though the assets in that sole benefit special needs trust may not be paid back to Medicaid because of the beneficiary, if they never receive Medicaid, it's because the person who funded the trust received Medicaid. And again, it must be for the sole benefit of the disabled person. You can name individuals, for example, if a parent creates a first-party special needs trust with an inheritance that is left to their disabled child, there has to be a Medicaid payback provision. But after that Medicaid payback provision, you can also name the parent's other children to receive any residual funds that remain in that trust. But this is also a reason why you may find that somebody has both a first-party special needs trust and a third-party special needs trust. I have many clients who are in that situation, who have received an inheritance directly, and therefore they have a first-party special needs trust, and then their parents or grandparents leave them an inheritance through their estate plan, and therefore a third-party special needs trust has been created for them. And in that situation, I advise parents and the trustees to use the assets in the first-party special needs trust first because of that Medicaid payback provision. Because since assets are going to be needed anyhow, it makes the most sense to use the funds in that self-settled first-party special needs trust to avoid that Medicaid payback and use those funds first and then use the funds in the third-party special needs trust, because they're all going to be available for the benefit of the disabled individual, but the beneficiaries that may be named to receive funds after the death of the disabled individual will be able to receive more funds through this third-party special needs trust because there's no Medicaid payback provision.